afternoon. We'll wait a couple minutes for people to sign on, and then we will get going. All right, so I know there's a couple people who have been emailing me who are having a hard time getting on because apparently the Wi-Fi in their rooms is just not working. So they are working with computer services to get that done, hopefully sooner rather than later for their sake. But there might be some people who are still trying to connect, and hopefully we'll be able to do so soon. So we are going to go ahead and get started. So today we will first finish our PowerPoint, and then we actually already have another assignment. Usually there'll be maybe one a week, but it just sort of worked out timing wise that there are two this week. So after I finish the lecture, we will be doing that. Yeah, and then we will go from there. We'll do the discussion. I made it 5 groups this time just because having the 6th is sort of awkward. So when there's 5 questions to answer. So I'm going to go ahead and share my screen for the world's least interesting PowerPoints. I think I mentioned to you all, I created these just because the last time I taught this class, just the board didn't make it feasible to write notes, and now I'm glad that they exist because they make it a little easier for you all as well. So I'm just pulling down the chat so that I can see if anybody needs to ask any questions. Alrighty, and we will go ahead and get started here. All right, so we've been talking about the history of the court system and, you know, sort of where the inspiration for our court system here came from. There we go. And so today we're going to talk a little more abstractly. What is justice? And there are different ideas, different definitions of types of justice. So distributive justice models suggest that a person will be more accepting of decisions and more likely to believe that disputes have been resolved appropriately if the outcomes seem to be distributed equitably. So distributive justice is, are the outcomes distributed equitably? Procedural justice models suggest that if individuals view the procedures of dispute resolution or decision-making as fair, as equitable, they will view the outcome as just, regardless of whether it favors them or not. So I would say this is sort of more where we're at in the US right now, right? That people believe because everyone goes through the same system that, somehow everything is fair and equitable. And as we've been hinting at, that isn't necessarily true if you're poor, if you're a person of color, right? So kind of keeping that in mind. Common sense justice is like everyday ideas we have about fairness. So ordinary citizens' basic notions of what is just and what is fair. And researchers have found evidence that the black letter law that we talked about on Tuesday on the books may be at odds with community sentiment. And there can be 3 discrepancies between the jurors' intuitions, so that common sense justice, and what is actually in the legal concepts and procedures. So the common sense context is typically wider than the laws, right? The laws are prescribed in terms of like, this equals this penalty. Whereas common sense justice is sort of thinking about things equitably overall, right? Jurors' perspectives on defendants' and victims' actions are more subjective than the law allows, right? So in theory, if we were just looking at the law, this is what happened, this is what punishment should be doled out as a result, right? But we don't necessarily see that in real life. And so our sort of subjective perceptions of people really can get in the way, right? And everyone has these. No matter how great we think we are, no matter how open-minded or liberal, we all have these ideas, these subjective ideas, and it might be something as subtle as this person reminds you of something that happened to you once, right? Or it could be as unsubtle, hit you over the head as racism, right? And then the third discrepancy here is that jurors take a proportional approach to punishment, whereas the law asks them to consider the defendant in isolation. So it's sort of a like, is this bad enough type scenario? And that's not what the law asks us, right? It's yes or no, essentially. So again, abstract concepts, and kind of gets at the fact that there's no one way to look at something and say, yes, this is just. All right, so in terms of federal courts, so in the US, there are layers of courts. There are federal courts, Supreme Courts, some areas have county courts, and then, specific municipality courts as well. So federal courts have jurisdiction over cases under the Constitution or laws of the United States. But they typically do not have jurisdiction over cases arising under state law. And this is the whole, again, if you remember back to like civics classes you took growing up or American history classes, right? This is the whole states' rights versus federal oversight issue that we have on a lot of different issues, right? Including like, how do we get the COVID vaccine out? So typically, federal doesn't necessarily come above state's law unless the plaintiff and defendant are from different states, because then it becomes which state tries them, right? So then it's easier to take it to a federal court. Federal courts include trials courts, appellate courts, and the Supreme Court, which is the one we all know about. So federal trial courts are called United States District Courts. And there's at least one district in every state. Obviously, the more populated you are, the more districts you might have. Federal appellate courts are called the United States Courts of Appeals. And these are also sometimes referred to as circuit courts. So if you've ever heard talking about a Supreme Court justice, like the Supreme Court decision rather, they decided to uphold the decision of the circuit court, this is what they're talking about, the United States Courts of Appeals. There are 13 federal courts of appeal divided into these geographical circuits. And the term circuit actually comes from back in the day when the judges would literally ride a circuit, like in their wagons or on their horseback, to different areas to oversee different cases. You would also have circuit ministers at that time where, they might only attend each church on their circuit one Sunday a month. So the appeals are assigned to 3 judge panels, and these judges examine the record. And the record is the documents that the lawyers believe the judges need in order to decide the case. So these are documents that come out of the decision made at the district court level. So they review the record. So this might be, different paperwork, images of evidence, things along those lines. They also read briefs submitted by the lawyers, and these briefs are the lawyers' written arguments about the case. And in particular here, what the lawyers would focus on is why they think the original decision made at the district court level should be overturned, or on the other side, not overturned. And then they also listen to the oral argument, the lawyers debate about the case before voting. And the panel decides by majority vote, so having an odd number of judges makes this possible. And then one of the judges writes an opinion explaining why the court decided as it did. So it's a sort of a mini version of what happens on the Supreme Court. Now, currently 9 justices make up the US Supreme Court. There has been some talk, although Biden himself hasn't necessarily confirmed this, that Biden may choose to add additional justices, and there's certainly precedent for this. Nowhere in the Constitution does it say how many justices need to be on the US Supreme Court. Just that one has to exist, basically, and should probably have an odd number of members for the same reason as the Courts of Appeals. So the US Supreme Court has the authority to review all cases decided on by federal appellate courts. The Supreme Court also has the authority to review state court decisions based on the Constitution or based on laws of the US. So it's not like any state court decision. It's one that directly relates to federal law or the Constitution itself. And the Supreme Court, as you can imagine, gets lots of different cases submitted to it to review. And they review only those cases that the justices view as most significant. So there are times where the Supreme Court will choose not to review a case simply because they feel another case in the precedent has already decided on this. There are other times where they're kind of waiting for a better case, quote unquote, to look at this particular issue. In that case, whatever the Court of Appeals decided is upheld. The Supreme Court, when they do decide to review a case, the order granting the review is called the writ of certiorari, and I'm probably butchering that again. Sorry, Latin scholars. And again, the court reviews only a small percentage of all the cases it's asked to consider, simply because they don't have time. Supreme Court cases are usually quite lengthy in order to make sure the arguments are adequately decided. They also take quite a bit of time to render their decisions, because again, these things have wide-ranging implications. So they want to make sure they do it well and they do it deliberatively. The Supreme Court is sort of an interesting entity in our modern era. So TV cameras are still not allowed in the Supreme Court. So reporters can go in and they'll release audio recordings, but there's still no video recordings, which again kind of creates this interesting sort of shroud of mystery around it. I remember a couple years back, John Oliver on his show Last Week Tonight suggesting that typically they just use the court sketches and that those are really boring. And so he said, we should try to make the Supreme Court more interesting so people pay attention. And so they taped some stock footage of dogs. Each dog represented a different justice. And Ruth Bader Ginsburg was like this tiny chihuahua. And he was like, use this, get people interested. I don't think anyone ever took him up on it. But, these are really important decisions. But I think because there's not video footage and we're such an image-driven world, sometimes it's easy to sort of like ignore it unless we're in really sort of hallmark cases like the Love is Love case a few years ago. Now, in terms of state courts, and granted, this is going to vary from state to state. There are 50 different states, not quite 50 different ways of doing it, but probably almost, basically. And they're typically divided into lower courts and trial courts. Lower courts have jurisdiction only over specific matters. These would be things like probate of wills, administration of estates, family matters, juvenile offenders, things along those lines. Family courts would be considered a lower court, and they handle cases involving divorce, child custody, child dependency. So children that asked to be emancipated would fall under family court. And then there are specific juvenile courts typically that deal with legal questions concerning juvenile delinquency. And again, depending on the jurisdiction, depending on the severity of the crime, they may choose to try juveniles as adults. If it's a murder and someone who's 16 committed it, they may bump that up. Trial courts typically decide any case that concerns state laws. Most criminal cases, so those like drunk driving, armed robbery, sexual assault, murder, are tried in state trial courts, although certainly, again, depending on the logistics, some of those may end up being handled in federal courts. Layla, I just saw your comment. Yes, we should involve more dogs in important decisions. I think that they would really guide us well, honestly. There were, a couple of years ago, I remember they were training dogs to sniff out cancer, and then I think I heard something where they were trying to train dogs to sniff out COVID in particular. So dogs have like way more skill sets than we even realized, possibly. State court systems also typically include appellate courts or courts of appeal, and also a state Supreme Court. So sort of mimicking that federal system. And again, what kind of cases, what kind of decisions can be made are decided by that jurisdiction. So for example, I believe just yesterday, the Virginia legislature voted to get rid of the death penalty in Virginia, for example. So, but some states still have it. Things to ponder. All right, problem-solving courts is where we get even more into psychological issues that might come up. So communities are increasingly creating these problem-solving courts to help troubled individuals cope with problems that brought them to court. So these really recognize that some of the things that make people end up in court for criminal offenses are actually really related to, say, mental health or other issues of living, right, that go on. So they really want to try to help those troubled individuals rather than punishing them. This approach, where the law is trying to be used as a vehicle to improve someone's life,
is called therapeutic jurisprudence. So this is where the law is used to improve people's lives. The law, the court, is sort of seen as a therapeutic process in and of itself. Examples of problem-solving courts, which we'll go into each into more detail, include drug courts, mental health courts, home courts, and domestic violence courts. Many characteristics of these problem-solving courts are unconventional. So, for example, the clients are able to speak directly to the judges rather than communicating through their attorneys. So drug courts are created to deal with offenders whose crimes are related specifically to their addiction. So it's saying, we know that you stole this because you were trying to get money to fuel your drug addiction. Drug courts offer treatment programs and supervision to drug addicted offenders. In exchange for successful completion of the program, the court may dismiss the original charge, reduce or set aside a sentence, assign some lesser penalty, or make a combination of these adjustments. So do they work? That becomes an important question, like in general, right? Do we want to put money into something? It doesn't work. But also just from a scientific standpoint, right? Does it work? So the findings are mixed. So people who graduate from drug courts are about a third less likely to be rearrested on subsequent drug charges than similar defendants who went through traditional court systems. And evidence suggests that even some violent offenders can be helped by drug courts in particular. So looks like yes, but again, not for everybody. And that kind of makes sense because we know about how difficult it is to treat addiction, right? And the person really has to be committed themselves to treating addiction. So it's not going to work if they are not buying into it. Mental health courts were developed for offenders dealing with serious mental illness. So things like schizophrenia, bipolar disorder that really become disruptive in your life. So history, I've actually been talking about this in my abnormal class on Thursday mornings. History of sort of treating people is once upon a time, and it wasn't necessarily good. We essentially used to take people with severe mental illness and just sort of shove them into inpatient facilities. And some of those were actually helpful, and sometimes they just provided a stable place for people to live, but sometimes they were horrible. Like Bedlam in the UK was just like, they literally chained people up and let people pay to come observe them like they were at the zoo. And, depending on the phase of history, they were crooked jailers who would just be bought off, and they would sort of inpatient, hospitalized, imprisoned essentially anyone they didn't agree with, or like women who had money that their family wanted, things along those lines. But on the same token, there wasn't really anything outside of that either, right? So in the 1970s, what was called deinstitutionalization really started. And this is a long-term trend of closing medical hospitals. And essentially they just closed them and didn't really put a system in place to account for those individuals. So this has left them without services, without medication access. So as a result, the mentally ill have experienced high rates of homelessness, unemployment, alcohol and drug use, and physical and sexual abuse. Many with severe mental illness now end up incarcerated. And if you've followed the news in our area, there's been some horrible reports of how people who are mentally ill are treated at the prison in Chesapeake. People dying, things along, just horrific, right? And if an offender is diverted out of the regular courts into a mental health court, then what happens is you have a whole team approach. So the mental health team prepares a treatment plan to lead to long-term psychiatric care and reintegration into society. So they're just from the get-go saying, Not how can we punish this person for what they did, but how can we help this person so this doesn't happen to them again? The charges are dismissed if the offender follows the treatment plan, and evaluations of mental health courts suggest they've been, again, somewhat effective, in particular in linking participants to treatment service and reducing recidivism. So again, not perfect, but certainly better than, what we say in clinical psych is treatment as usual. So justice as usual. Homelessness courts aim to reduce homelessness by dealing with landlord and tenant issues and addressing the underlying causes of homelessness, mental illness, poor job skills, language barriers. And so they'll do a lot of the same things that, say, like the drug courts or the mental health courts will do as well. And evidence here shows there's a reduction in low-level crime and decreased recidivism by people who go through homelessness courts. Domestic violence courts in particular have coordinated efforts to hold perpetrators accountable, enhance victim and child safety, and promote informed judicial decision-making. And this is really important because even very intelligent people don't understand what happens to people who are survivors of domestic violence or survivors of sexual assault or things along those lines. We'll talk about this much more later in the semester. I actually purposely put our chapter out of order about victims just because I feel like it helps us to get to know each other better before we dive into that issue. But for example, there are things that happen in your brain when you're traumatized. There are ways that your brain processes things that actually make it more difficult to tell a linear story, that make it more difficult to react in a way that we would expect someone to react. And then we know that with domestic violence in particular, it is extremely difficult to leave those relationships. And in fact, you are most at risk of dying as a result of your abuse when you try to leave. So domestic violence courts recognize all that and want to educate the judges or juries who are involved in those cases. So they involve specially trained judges and staff, coordination among community resources, and close monitoring of the perpetrator before and after the case disposition. But they differ from other problem-solving courts in important respects. They start from the premise that the offender's behavior is learned rather than rooted in, something like an illness, right? Therefore, court proceedings are primarily adversarial rather than therapeutic. And both victims and perpetrators have actually expressed satisfaction with the way that the process goes and also with the outcomes. And compared to traditional courts, domestic violence courts process cases more quickly and also have higher rates of guilty pleas, which is a big deal because not a lot of people end up being held accountable for domestic violence for a whole host of reasons. In addition, perpetrators are more likely to comply with judge order conditions, which is really important because you can have a judge pass things down all day, but if the perpetrator doesn't comply, it's not going to help, right? So like you can get a restraining order, but it's just a piece of paper, right? They don't set up like a barbed wire fence around your property. It's just symbolic, and you can call for help if someone violates it, but sometimes that threshold, right, is too short. So some criticism here. So some people argue that threatening punishment to coerce rehabilitation is unfair. And again, as someone trained in clinical psychology, you kind of have to wonder, like, how effective is it to like force someone to get better? Also, guilt or innocence isn't necessarily determined by a trial in the same way as in traditional courts, right? So like domestic violence courts just come with the assumption the offender is the offender. So, while that may be the case, some would argue perhaps we're losing a bit of due process there. Prosecutors also feel pressured in these courts to favor rehabilitation of the offender over protection of society. And the defenders feel pressure to plead guilty for their clients and inform the court of client's failure to comply with terms of probation, which again isn't something we normally would focus a lot on. So it does kind of pigeonhole things in terms of what your options are, but at the same time, there are some suggestions in the research that this might be more effective. All right, so now we've been talking about the courts. Let's talk about the people within them. So judges, and these are people that we need to kind of be thinking about their mental health as well, right? And their mental stability. So many state court judges, not in Virginia, but in many other places, are actually elected. So I remember when I was in Michigan, which is where I voted the first 10 years or so I could vote, you actually voted on judges. And it would be kind of funny because it would be like 18 spots to fill and there'd be 18 people on the ballot and they'd be like, vote for no more than 18. I'm sure there were times it was contested. But the idea is they are then sort of like beholden to the people, and you could in theory recall a judge by a vote as well. So I believe that happened to the judge who sentenced, or didn't really sentence, Brock Turner after his sexual assault case, because people were so dissatisfied. So typically what happens is the governor makes an initial appointment, and then the judges put up for popular election and retained or not. If retained, they serve a number of years, after which they again run for retention. Supporters say this makes judges accountable to the public. And again, a judge who makes unpopular decisions could then, in theory, be removed. Judicial retention elections may invite pressure, however, from special interest groups. Technically, judges are not supposed to have political party affiliation, right? We know that some do. We know that it's hard to be totally neutral on everything, right? But people argue that elections might sort of like make that more salient. And there is concern about judicial elections posing a threat to fairness and impartiality of the courts, right? If you're worried about being reelected, that might influence how you make decisions. Again, in places where you're pretty much going to get reelected, I don't think that's as much of an issue. Now, but in some cases, they're just appointed. So I believe Virginia uses the system, the federal courts use this system, right? And it's really interesting because typically who's ever in charge will try to appoint judges who sort of side with them. Again, even knowing that judges are supposed to be neutral, we know they tend to have patterns in their decision making. But that can backfire, right? So all of the judges who rejected Trump's attempts to undermine election results in states, the vast majority of them were actually appointed by him. So it doesn't mean they're always going to agree with everything, right? They're still going to look at the rule of the law, and sometimes they'll surprise you, right? Kavanaugh, who isn't my favorite justice ever because of his history, he has had times where he has been much more moderate in his decisions since he's been on the Supreme Court than I think anyone expected. So I think that, you know, that can kind of go either way. And sometimes judges get kind of, I don't want to say caught up, but they focus more on certain details of a case than others. Until recently, until probably the past 40-ish years, judges were male. They were male, they were white, right? And still majority cisgender, still majority straight, right? So what we're starting to see is more and more women and people of color being represented on the bench. Again, still vastly underrepresented. It began to change during the presidencies of Jimmy Carter and Bill Clinton. Jimmy Carter appointed 21% women or minorities. Bill Clinton appointed 49% women or minorities. I don't know what the record was during Obama's presidencies. I'm guessing it was comparable or better. I And I'm guessing Biden's would be even better. He has the most diverse cabinet in history. So it'll be really interesting to see sort of his appointments. And there were actually judges who specifically waited until Biden was inaugurated to resign. Like literally they resigned that afternoon, like 2 hours after he was inaugurated, because they wanted him to replace them, which is really interesting. And again, kind of brings up questions about neutrality, right? That's really important to keep in mind. So it is reasonable to ask, pretty much everything's an empirical question when it comes to psychology, right? Do male and female judges actually view cases differently? So this is a bit of an older study. It was between 1981 and 1996, but they looked at 292 federal cases, and they showed no effects of judges' gender and also no effects of judges' race on their decision. Men and women, white and people of color judges were equally likely to rule in the favor of the plaintiff in cases of sexual harassment, for example. So it seems like, again, that the vast majority of the time, these people are judging based on sort of their interpretation of the law. That's really what they're supposed to be doing. Now, I bet where it makes more of a difference, and again, I'm sure this is an empirical question someone has asked, but is in terms of how they interact within the courtroom. And so I think specifically, and I'm going to blow my nose real quick here, so I'll mute so I don't. But I think specifically about the Larry Nassar case. So if you're not familiar with this case, horrible, horrible man, abused so many underage gymnasts for years and years and years, and USA Gymnastics just covered it up. And the female judge in that case was very survivor oriented. And so not only in how she interacted with the survivors, but just the fact that she let, I believe there were like 200 plus, might have been 300 plus survivors come and make impact statements, essentially saying how what he had done had affected them. And again, maybe there would be a male judge who would do the same thing, right? But I think there was probably some element of her gender in that, even though it didn't affect her overall. Yes, are you talking about athlete A, Jordan? Yes, horrible, horrible. Focuses on Maggie.
Yeah, I am.
Yeah. Maggie Nichols, who was athlete A, and not only was it like ignored, but she was sort of blackballed by USA Gymnastics, essentially. Really, really bad. Hard to watch, but well put together. And actually, if you want to see just like real power, you can find a lot of the victims' statements. So like gold medal winners like Jordan Weaver, Ellie Raisman. And just really, it's hard to watch, but it's really powerful to watch. Those are just on YouTube. So what else influences judicial judgments, particularly in appellate cases? Because remember, they have to decide whether to overturn what the lower court has done. So in the legal mode model of decision-making, they dispassionately consider the relevant laws, precedents, and constitutional principles. Judicial bias has no part in decision-making. In the attitudinal model, judges view the facts of the case in light of the ideological attitudes and values of the justices. And so most favor this model, and this truly is, I think, what happens the majority of the time in the US, but of course that doesn't mean they ignore the legal precedent. So how do judges decide these cases? So models of human judgment in general distinguish between intuitive and deliberative processes. So intuitive processes occur spontaneously without careful thought or effort. Deliberative processes involve mental effort, concentration, motivation, applying rules and laws. And really interestingly, in general, we hope that judges are using deliberative processes, right? But research has shown they use intuitive decisions based on for decisions like how much to award in damages in civil suits, right? There's not like a clear cut and dry, how much should you give someone, right, who, you know, was hit by a drunk driver. things along those lines. So they tend to use intuitive decision processing there. Also describing litigants' conduct, and also deciding which evidence is admissible or not. So if we think about like expert witnesses being admissible or not, they tend to be more intuitive with that. So one of the things you are going to look at on your assignment is the risks of being a judge. And so one of the cases that is highlighted, and I've included a link so you can learn a little more about him, is the case of Judge Roll. So Judge Roll was an Arizona judge, and actually 10 years ago this year, he was at the event that Representative Gabby Giffords had, where domestic terrorist, assassin, I don't know what you want to call him, came up and shot her and several other people point blank in the head. Judge Roll was one of those, and he was actually killed. He didn't survive like Giffords did. This is rare, but it certainly can happen. There have been cases, especially when you're deciding on high-stake cases or sort of a stereotype, right? Where there's a network of criminals, so like a mob case or something like that, where judges take extra precautions because they know their life might potentially be at risk. Alrighty. I'm gonna put this to the side. And your assignment has to do with judges and sort of the psychological issues that affect them, and also the psychological issues they interact with as they oversee these cases. So let me grab the link for y'all for that. And same thing I did last time. One of them does refer to a box in your book, and for anyone whose book hasn't come yet, I went ahead and copy pasted the box, took my high quality cell phone photo of it, and it's on the first page. So I'm going to do 5 groups this time, just so it's easier, group per question, and so your groups will be like a teeny bit bigger, but I think they'll still be pretty manageable. So let me go ahead and set those up really quickly. Make sure that you open the link while you're at it. Let me get the breakout room set up here. Yeah. So 3 or 4 people in each room. So pretty comparable to last time since we have a few people not here today. You'll have 20 minutes and then we'll come back together and talk through everything. So take note of your room number because that's the group number you will use just like last time, and that's where you'll answer on the sheet. All right. See you all in about 20 minutes.
I didn't get the link.
All right, it should be in the chat now.